Welcome to the Supreme Court of the United Kingdom, where today we're continuing to hear the appeal in the case of Hoof and the Commissioners for Her Majesty's Revenue and Customs. We're currently hearing submissions on behalf of the taxpayer, Mr. Hoof, presented by Mr. Julian Ghosh, Queen's Counsel. So I'll turn now to Mr. Ghosh and invite him to continue his submission.
I'm very grateful, my lord, and my lords, good morning. Please may I check that you can all hear me, because I gathered from Theo that, oh good, okay, well that was easy. Please may I make submissions on the meaning of discovery. That should pick up points made by my Lord Briggs towards the end of the day yesterday, and also touch on a point made by my Lord Legate, which I'll come back to when I have to deal with staleness. Discovery. So we're looking at section 29, it's at page 860, and we know that as a matter of authority, it means to find out. Find out what? Find out an insufficiency of tax, because that's what this case is about. And that means a liability to tax, because the assessment to tax has become insufficient. It doesn't mean, clearly, that the taxpayer owes tax and the revenue is trying to recover it. That's a whole different part of the tax code, section 65 to 68, to recover the debt. So it's nothing to do with that. So the question then is, if discover means find out, find out that insufficiency, find out why the liability to tax, the assessment, is insufficient. Why, the way I put it yesterday, why the number is wrong. And that's the exercise that needs to be carried out by an officer or the board. And they do that in pre-self-assessment days by looking at a previous assessment, post-self-assessment, sorry, in pre-self-assessment days by looking at the revenues assessment, post-self-assessment by looking at the self-assessment. Now, I have made a submission, and well, I think it's right. If a taxpayer simply tells the revenue from day one, you think the law is X, I think it's Y, I have self-assessed at a particular number, minus 13,000. And here's why I've done it. It's an employment loss. I've carried it back from 2008 to 2009. Then in my respectful submission, the reader of that self-assessment doesn't discover anything. The revenue is protected because the revenue can raise an inquiry, and there's no time limits on that inquiry. There are all sorts of rules and cases to do with the taxpayer asking for a closure notice to say this has gone on for long enough. That's a separate conversation. So really what I've said is my first point on the meaning of discovery. It does mean to find out. It doesn't mean to be told something. Second point. Oh, sorry, I did say that I was going to pick up a point made by my Lord Briggs, because my Lord Briggs said, well, can it be said by inference that a revenue officer, just having come to a conclusion based on either new evidence or a new legal analysis, must have accepted the self-assessment, because that's what tells me, makes visible that there's been a change of thinking. And I'm sorry, forgive me. And the answer is, if that's what the officer has done, that would be a discovery, all right, but they must plead it and prove it because the burden is on them. But it could easily be that there was no discovery, there didn't have to be. Now, there's a further point to be made.
Lord Legate has a question for you.
Oh, I'm very sorry, my lord. I didn't see. Please.
I don't really see how where this linguistic analysis takes you, Mr. Ghosh. I mean, it's a perfectly reasonable reading of the words, isn't it? To say that an officer of the board who comes onto the case for the first time previously had no view one way or the other about whether the amount in the assessment was sufficient or insufficient, then takes a look at the file and forms the view that it's insufficient. That could be a discovery.
It absolutely could, my lord, but maybe please may I respond and answer your question by saying this. If that's what that officer has done and the revenue plead it and prove it, then that's a discovery. That's no problem. But he or she has got to do that, as opposed to, in contradistinction to, a circumstance where they say, look, this taxpayer hasn't paid enough tax. I think they should pay the revenue £455,000. They haven't. Do whatever you need to do and raise an assessment. That's got nothing to do with, that second approach has got nothing to do with coming to a new view about an insufficiency of tax. So what my Lord Legate says is that linguistically, yes, of course, a revenue officer can come along and say, well, looking at this self-assessment, doesn't seem right to me, and I shall, by looking at either fresh evidence or applying a new legal analysis, come to a view. That view shows me that that number is wrong, it's too low. And then if that's what I think, I shall raise a discovery assessment. That's fine, that's no problem at all. My point is, they need to show that's what's happened.
Well, I'm not sure what's missing on your case, because the first tier tribunal found that Mr. Williams discovered an insufficiency, just in the sense that he formed the view. And that finding was interfered with because the upper tribunal thought that you couldn't have a discovery where somebody else within the organisation had already formed that view. But if you're not maintaining the upper tribunal's position, then it seems I can't see what was wrong with the first tier tribunal's finding.
I'll show you the first tier tribunal's finding again. If I could please complete my submissions, and I'll return to your question with your permission.
Cool.
The upper tribunal, and this was my complaint, and the first tier tribunal, this was my complaint, made that finding on the basis of no factual analysis at all. That was my complaint. They said the threshold is low, and then with a complete non sequitur, that tells me that Mr. Williams made a discovery. That's my complaint. So everything's missing in my respectful response to your lordship's question. I'll go back and show you. It's paragraphs 44 and 45 of the FTT's decision. But my respectful response to the point your lordship has just made, my Lord Legate, is that that's a jump to say, well, the first year made a finding. Well, no, it didn't. Not an intelligible finding, and not a finding that's sustainable on the basis of an analysis of any factual evidence. And I will show you this, my lord. I'll go back to it. Please, my lord, Lord Sales.
Yes, Mr. Ghosh, may I just ask to check on that? Was there an appeal by Mr. Tooth in relation to that factual finding by the first tier tribunal to the upper tribunal?
I think it was a respondent's notice. I'll come back to your lordship on that. But because that finding of a discovery, of course, ended up being purely obiter, because the case was decided on all the other grounds. So it's a curiosity.
Right. So if I could broaden the query as to, was that point made to the upper tribunal in any way?
Oh yeah, I complained. I mean, in fact, there was a spat because I complained that the revenues pleadings were incompetent because they just said there was a discovery. those behind Ms McCarthy may recollect it if they were there. The Revenues then Council got very annoyed and said, oh, well, you shouldn't be calling my submissions incompetent because they're not. And I said, well, yes, they are, because you haven't actually pleaded any facts that let you say you've made a discovery.
Yes, thank you. It would be helpful just to have the page references together and all the respondents' notice.
Please may I, if my junior is listening to this, can he let me know?
Yeah, thank you.
That would be helpful. So, and just about that, my Lord Sales, even if I pleaded nothing, because the burden's on the revenue, I did plead it, because the burden's on the revenue, this is not controversial. I'm going to show you a case. They need to show that they'd made a discovery. I'm going to show you a case. It's a case of purchase. But I mean, I did plead it as it happens. Now, coming back, I've said discovery means to find out. If you've been told something that's not discovering anything, and you need to show me, you the revenue, that you've gone about this exercise by looking at facts or looking at legal analysis to say this number is wrong. Not in contradistinction. I want tax from you, and one way or another, do whatever it has. I instruct others to say, do whatever you need to do to get this tax back. Further point, can something be discovered only once? In which cases, and this taps into a point made by my Lord Burrows. So officer number 1 at desk number 1 makes a discovery, does nothing about it. Officer number 2 says, oh, well, Smithers hasn't done their job properly. I'll do it. Now, answer, I think that is the right approach. That's linguistically looking at the subject matter of the discovery. So the insufficiency of tax, and once it's discovered, once it can't be, as it were, rediscovered. Does that make life intolerable and terrible for the revenue because they work in teams? Well, of course not. There are 2 relevant provisions. Provision number 1 is section 2, subsection 4, which you were shown yesterday. That's supplementary bundle, page 8. That lets one officer continue a process begun by another officer. More relevantly, actually, to this case, is section 1131 capital B. That's at page 879, because that lets an officer delegate duties. And that was addressed in a case called Burford and Durkin. It's tab 29, page 1166 to 1176. And you'll find that the general proposition, the assumption that authority which is conferred on one officer has to be carried out by that officer subject to delegation, was accepted by the Court of Appeal. References at page 1171. That was the principle advanced by counsel for the Crown. It was Lord Justice Moses, but in his capacity as counsel, and accepted by the Court of Appeal at 1174. Now, just before I go on, just for your Lordship's note, respondents notice that making this factual point, page 311. Now, let's say I'm wrong about that. Let's say something can be discovered more than once, because the reference in section 29.1 to an officer means any officer. And so long as that officer makes a discovery, finds something out, that's enough. Who cares if a previous officer had found something out? Linguistically, that's absolutely tenable. Of course it is. I respectfully advance the first, because that is more consistent. That is more consistent with the notion of finality of the return plus self-assessment plus inquiry window ends, and discovery assessment. But even if the second view is right, any officer, and this actually now taps right back into my response to my Lord Legate. What's the evidence in this case as to the exercise carried out by Mr. Williams? Because my Lord Legate asked me, what's missing? My respectful response is everything. If you look at the emails generated by Mr. Williams, which were replicated in paragraphs, I think it was 34 and 35 of the FTT's decision. If you had two counsel fighting as to what was going on here, was it Mr. Williams saying, I don't know anything about self-assessment, I really don't, but you know what, you're telling me this guy owes tax? Yeah, absolutely. Raise a discovery assessment, get it back. That's what the upper tribunal actually were concerned about. They said we have serious concerns. That's what happened. It's at paragraph 88, little 7 at page 201. I'm not saying that's what happened. I'm choosing my words very carefully. Or else what might have happened was Mr. Williams said, the self-assessment is for minus 13,000. I think that number is too small. Of course, looking at and making a legal analysis following Cotter, I shall absolutely delegate the making of a discovery assessment to Ms. Thorley, who in turn delegates it to Mr. Anders. Now, I said it matters that the revenue, and this now again is supplementing my response to my Lord Legate. We need to know which one of these two it was. And the revenue haven't shown me. They still haven't actually. They said, oh, yes, my Lord Legate.
You're approaching it, Mr. Ghosh, as though the revenue have to come along now and prove it prove the facts. But that's not the position, surely. The position is the first tier tribunal made a factual finding, and you have to identify the error of law in that finding. And I'm not completely clear at the moment what that is. Are you saying there's simply no evidence on which a reasonable tribunal could make that finding? Or are you saying that they made a misdirection as to what the law was in arriving at that conclusion? Or both?
I'm saying effectively both, but it's more apt to call it a misdirection. They didn't address the question, which is addressing where it was that they can identify an exercise where the revenue specifically looked at the minus 13 figure, decided it was too small, and then on the basis of legal analysis decided that 13,000 figure should be 455. That's exactly what I'm saying. And actually, why don't we just do this now? If your lordships look at paragraphs 44 and 45, which is all we've got in the FTT decision, it's page 219. Your lordships will see that there's reference to August 2009, not Grunberg. I've already made the point that paragraph 44 identifies two separate submissions from me. And then at 45, my non-rhetorical question is, where is the identification of the exercise? So that's my point. Please may I also show you, while I'm at it, Burgess, it's at tab 41, page 1391 to 1392. Please may your lordships take up, well, electronically, page 1391. Now, what Burgess was to do with was a case where the first tier tribunal had found, I'm sorry, has my Lord Hill's got it? They had found that the taxpayers had underdeclared tax, understated tax. They'd found that. And they made a discovery assessment, but they had not pleaded because the taxpayers hadn't challenged the discovery assessment on its terms. So they hadn't pleaded the revenue that they'd undergone the exercise of making a discovery assessment. They hadn't pleaded and proved that that exercise had been done. And what the revenue had thought was, because the taxpayer hadn't challenged it before the first tier tribunal, hadn't challenged it in their pleadings before the upper tribunal, didn't matter. Held by the upper tribunal? Absolutely not. Because the revenue, the burden on the revenue in making a discovery assessment means that they've got to plead and prove it, whether or not the taxpayer pleads anything. Now, I don't need to hide behind this. I made my pleadings perfectly properly. But the point I'm making is that the conversation I'm having in response to my Lord Legate is that the revenue have a duty to plead and prove that they've conducted the exercise of making a discovery assessment, that they made the discovery and they have identified separately the deliberate behavior or careless behavior or the absence of information. So all I'm saying is that makes good my proposition that the burden of proof is on the revenue. So my response is, I have got no embarrassment in saying, look, paragraphs 44 and 45, if you read the FTT, they haven't identified any exercise. In a world where the burden of proof is on the revenue, certainly not Grunberg. Continuing that thread, I've said the whole problem here is that you can't tell if the revenue have conducted this exercise or not, because it's not been properly pleaded, not been properly proved, not been properly found. The revenue space here is messy because you've already seen that the revenue have specifically disavowed, because I've said, look, whatever the meaning of discovery is, there's no identification of the exercise. Looking at the revenue's case now, on either view of discovery, whether something can be discovered only once or whether it can be discovered more than once, the revenue have said expressly that they're not relying on Cotter. That was their that was changed from the statement of case, but it was in their FTT skeleton at paragraph 55, page 428. Expressly not relying on Cotter. I think the not was in italics. Now, they then say, aha, well, they didn't then say, but they now say it was a Grunberg letter. But that's Cotter. the Grunberg letter was all to do with paragraph 27 of Cotter. So there's a real inconsistency in the revenues case. More relevantly, Ms. McCarthy tried to take you to Mr. March's witness statement yesterday. He doesn't mention Grunberg letter. Mr. Williams doesn't mention the Grunberg letter. The letter of 24th October 2014 doesn't mention the Grunberg letter. The view of the matter letter doesn't mention the Grunberg letter, and the statutory review doesn't mention the Grunberg letter. The only place your lordships will find the Grunberg letter mentioned, the only place, mind, is in when the Revenue changed counsel in the application for permission to appeal to the Court of Appeal, and then before the Court of Appeal. Now, you were shown yesterday paragraph 4G of the Revenue's upper tribunal skeleton. But what that says is, following correspondence, there was a discovery in October 2014. What does that tell me about whether or not there was a proper exercise conducted? And as I say, we still haven't got, because the Revenue aren't saying now, the discovery was on the date of the Grunberg letter on 11th March. They're saying that led to a discovery in October 2014. How? When? The assessing officer was Mr. Williams. He doesn't mention anything about it. Well, you've got the point. I can't face repeating it. So we're in a place where the Revenue's case is internally inconsistent, and there's no evidence of a particular exercise identifying that the 13,000 figure was too low. And in parentheses, they always knew it was too low, because that 14th August 2009 letter, you've seen it, it not only responded knowing, of course, it was an employment loss, but he knew that it was carried back from 2008 to 2007-8. So from 2008-9 to 2007-8. And actually, if you give me one moment. Yeah, it's tab 50. Please don't turn it up. But if your lordships were to turn it up, you'd find that that letter in full also addresses how the loss came from a DOTAS scheme. So they knew absolutely everything there was to know about that loss. Mr. Tooth had told them. Now, as a matter of approach, in approaching the construction and application of section 29, what's the correct approach to take in giving the word discovery a meaning, as to whether something can be discovered more than once, as to the point of principle that the burden of proofs on the Revenue, they've got to identify the proper exercise. What's the correct approach that the courts should take? Now, Parliament enacts provisions to protect the Revenue, and then and those provisions ought to be construed and applied to protect the Revenue, and the Revenue are entitled to the protection of all courts, including this court, in applying and construing those provisions properly. If those provisions don't apply to a taxpayer, that taxpayer is entitled to the protection of this court. Otherwise, what's the point? And just while we're here, my Lord Legate has pressed me a number of times today and yesterday How can I say that there was no evidence? Well, I've shown you about the absence of any identification of a proper exercise. And the revenue protected. Oh, my Lord Burrows.
Yes, thank you. I'm still somewhat puzzled as to where this is actually getting you. Am I to understand that you're saying there was no discovery at all, or that there was no discovery in 2014, or that there was no discovery in 2009? And the reason I ask that is that at this moment in time, it doesn't seem to matter, as I understand it, whether the discovery is in 2009 or 2014. I'm looking at what the upper tribunal said in relation to that matter. They take it as read that there's no problem at all about saying there was a discovery in 2009. And if you look at page 199, paragraph 83, they say, well, there's no problem about that, but then there's a problem about staleness. But if we were not to accept staleness, it would make no difference for the revenue's point of view, whether it was 2009 or 2014, would it?
Absolutely not. Please may I make it clear, I'm ashamed that I'm having to make it clear at this stage to your lordships. I am saying there is no evidence of any discovery at any stage. And if you think there is, I shall respond. The 2009 letter, the upper tribunal may have thought, but they weren't making a finding of fact. Again, it was all obiter, because they decided the case on all the other grounds. But I am absolutely saying, and I said it yesterday, the revenue were told. They didn't have to discover anything, didn't have to find anything out, because they were told by Mr. Tooth in his tax return the nature of the loss, why he was assessing it minus 13. So I'm ashamed of having to repeat this. I'm absolutely saying that wasn't a discovery in August 2014. That's the pleading I made before the first-year tribunal. And what's more, there was no discovery in October 2014. And in any event, the revenue have disavowed August 2009 as discovery, so they're concentrating on October 2014. Please, my Lord Briggs.
Leaving aside your pure pleading point, in a sense, is it really right to say that the disclosure made in the tax return told the revenue that the minus 13,000 figure was wrong and too low? It went as far as saying it's based on a scheme, with giving the scheme particulars. It went as far as saying, we appreciate you may not agree with us and may want to open an inquiry, but it didn't say, and by the way, we know we're wrong. On the contrary, it asserted in the declaration on the form that it was right. And even if the revenue is reminded that they may well be suspicious about it right, nonetheless, the revenue have to look at it and react to it and say it's wrong before they could take any of the steps which they later took, don't they?
Well, that's a non-rhetorical question, my lord. I would say Mr. Tooth could not have done any more. I think we agree on that, to show the revenue.
Absolutely.
We then go on to say, well, does that mean that the revenue need to make a discovery, having been told, you're likely to disagree, that they think that the minus 13 figure is wrong? I don't think so. That's not finding anything out. That's using the knowledge I've got already, knowing that I disagree, because this scheme had a DOTAS figure, so the revenue had already known about the scheme, to say, that's right. I don't need to find anything out, because I always thought that there's no loss. You're telling me that you think there's a loss. I don't need to find out that I think I don't have to find anything out, because we both know. So, and if you're not with me on that point, and it's more than a linguistic point, it's a curiosity. I want to move on to the other points sooner rather than later. But it's a yes, my lord, Lord Sales.
Well, sorry, you finished the point you were about to make, Mr. Ghosh, and then I'll ask my question.
I'm very grateful. It's a curiosity because most cases before this court involve big constitutional issues, and you forget there's a winner and a loser, and that decision will play out in a very real way. This case is quite prosaic about putting figures in a box and telling the revenue everything, and the revenue saying, oh, can we be said to make a discovery or not? Which seems like a silly linguistic point. Actually, it's not. Because underlying this conversation is a question as to whether the revenue can then just make an inquiry, which they're absolutely entitled to do. So we don't need to have this conversation. And then if they don't, can they make a discovery because they've found something out? On my Lord Briggs's analysis, the nanosecond after receiving the self-assessment, because they've had to say, oh yes, it's this type of employment loss. We've always thought that didn't work. That's my discovery. I'm very sorry, my Lord Sales. Please, your question.
Well, I think it's probably fair to say it's pursuing the same line of thought. When they receive the tax return, they see the taxpayer making a claim that the relevant figure is the minus 13,000. But don't they then have to make a legal evaluation of their own, whether to accept that figure? And the taxpayer has presented arguments why they should accept that figure. It's logically possible that they might be persuaded by that, even though they have been doing some thinking previously. But in terms of the evaluation that they have to make, is that not a new legal evaluation? And I was just wondering whether it's really equivalent to the new legal evaluation that happens in a case like McKinley's Trustees, where all the facts are known, but a new view is taken about the legal significance of the facts which are known. Sorry.
That could be the case, or it could be the case that the revenue have already made their evaluation because they've already made their legal assessment about the employment loss arising from this DOTAS scheme. So there's no further legal evaluation to be made.
But isn't it in the nature of self-assessment that there is? Because you start with the self-assessment and the revenue then has to make a decision whether to accept that particular self-assessment.
I'm not sure I'm going to be able to take this analytically any further forward. I say there's a distinction between, if I know what the law is, I've always thought that's what the law is, and you then come to me and you say, actually, you may disagree. You think the law is X, I think it's Y. Because I think it's Y, I've got a minus 13 figure. I, without any need for any further legal evaluation at all, say, well, oh, you're one of those. Actually, no, you're wrong. Or if you and if that exercise counts as a discovery, then I lose this point. That's quite right. I do. I don't think I should, because that's the whole point of an inquiry, where I can then say, well, I've always thought this was wrong, but let's look at this further. Not a discovery. A discovery is different.
Yes, thank you very much.
I'm very grateful. So that's where I am. As I say, I'm not sure I can take this much further forward because I can't do any more. What seems to be at issue is the answer to this question, even if the revenue have taken a view of the law, bracket, we don't know because there's no evidence, but we know that the revenue knew about the scheme because it had a DOTAS number, close bracket. But even though the revenue knew exactly what sort of employment loss it was, exactly what the revenue's legal position was, nevertheless, a recognition that a particular assessment took a different view amounts to a discovery. And I say it doesn't, it could be said against me, it does. I can't do any more to say it shouldn't, because that's not finding something out linguistically. And it's not just a linguistic point. It makes it feeds very properly into the difference between an inquiry, which the revenue can raise immediately, and a discovery, which is to find something out which is new. And in any event, I say, look, even parking all this, and again, I can't do more than put this to your lordships. There is no identification of any exercise, of any evaluation by anybody. Certainly not by Judge Brooks in the first tier tribunal.
And I think you say that if the first tier tribunal was wrong in their conclusion that there was a discovery in 2014, wrong in law, because let's say there were no facts to support it, and it's not for a higher court to substitute some earlier date for the discovery, which the revenue isn't itself asserting. It's just they failed to prove their case. That's really the substance of your pleading point.
Absolutely right, my lord.
Yeah. Okay. Thank you.
And it's not just a pleading point. As I say, it unearths a big point about the duty of the revenue. Just so I'm clear, I'm not hiding behind a pleading point.
It's presumably a big point because even the revenue acknowledge that if there is a long gap between the discovery and the assessment, then there may be a judicial review type challenge. So that sitting on the fence about when it occurred isn't a satisfactory way of enabling the taxpayer to pursue any relevant rights.
Absolutely, my lord. I don't want to work myself up into spending too much time enthusiastically agreeing, because I need to get on. But absolutely right. And
Okay.
Miss McCarthy said repeatedly, "Oh well, we don't quite know when this was." I think her words were, "It doesn't matter." Well, of course it matters. Anyway, as I say, I won't work myself up into pleadings rage. I shall move on to the point about permission. Now, about permission, please may I ask your lordships, because to explain why the revenues case is so bad, please may I ask your lordships to pick up Beagles. It's at tab 50, page 1644 to 1645. If your lordships have got that, this actually makes a point that my Lord Reid made, and in my respectful submission, he nailed it. The concept of newness, discovery, has two quite distinct applications. My Lord Reid was less generous. He said there was confusion by, I think, the upper tribunal in conflating these two ideas. But discovery, needing to be new, has two quite separate roles to play. Role number one is that the discovery itself has got to be new. You've got to find something out. I've pretty much done that point to death. What this passage is saying is, and quite separately, there's a question that if there is a discovery, can that discovery, that new thing, become old, become stale? So when a court talks about newness, we have to be quite clear in which sense they're addressing the question of newness. Is it the fact of the discovery itself? Or no, there is a discovery, everybody accepts a discovery, but has it become stale? It's two different things. Now, the reason that this is so important is please may I show you the Court of Appeal's judgment. If you pick that up, please, it's at page 161. Start there. Please may I start there. if you look, please, at paragraphs 53 and 55, at 161 and 162, you'll see that they're just narrations of the first year tribunal's decision. There's a reason I'm telling you this, I promise. If you then look at, please, paragraph 61 at page 163 to 164. Well, paragraph 60 as well, actually. This is where the Court of Appeal say, look, the parties agree that the discovery's got to be new. Staleness wasn't an issue. It couldn't have been an issue in the Revenue's new case in the Court of Appeal because they were saying it was October 2014. At 61, it's true. Having looked at both notions of newness, because when they recited Charlton, they said the nature of a discovery, the way I put it in my case is that there are three propositions here. Is that the discovery needs to be something new to an officer. Second proposition, the requirement for newness doesn't relate to the reason, but to the conclusion itself. Third proposition is staleness. Must be made within a reasonable period, but that's different from the first two. And that's endorsed by the Court of Appeal. But then what I'm going to show you is that precisely because the Revenue had changed its case and were pleading the Grunberg letter, staleness had nothing to do with my submissions and nothing to do with what the Court of Appeal were talking about. When they were looking at newness, they were looking at the newness of the discovery claimed by the Revenue. Whether or not the thing that happened in 2014 was truly new. Not that there had been a discovery which had become stale, not that. If your lordships look then, please, at paragraph 67. That's at page 165. That's simply making the point that I've been banging on about in response to my Lord Legate. But then at 70, now I wonder, please, if your lordships might just let me know when you've read 70, because this paragraph's important. I don't want to take this at a rush. Please may I continue? I'm very grateful. So what they're saying at 70 was, look, it's not at all clear. And I don't want to call this a pleading point because it devalues how important this point is. It's not at all clear about what this Grunberg letter had to do with anything Mr. Williams decided. I'm just saying there was a realization that was a new case that this happened in October 2014. But then if your lordships continue at paragraph 71, just over the page on page 166, At little 1, your lordships will see the Court of Appeal are saying at little 1, the revenue saw that he was claiming immediate relief. At little 2, the Court of Appeal are very tentative about how they're looking at the evidence. It's at least a possible view that they were fully aware of an insufficiency. They're not making any findings there. They can't, because the Court of Appeal knows its job as a higher court. Then at page 166 at little 7, you'll see that they say, well, look, all that happened was the revenue told Grunberg that Mr. Tooth was similar to Mr. Cotter. But then if you turn the page to 167 at little 8, again, the last line is all to do with there's no evidence. And then at paragraph 72, same page, this is the burden of what the Court of Appeal found. And it's 1, 2, 3, 4, 5, 6 lines up from the bottom. It's the sentence that reads, there was no discovery of an insufficiency either on the receipt of the Grunberg letter or in the review of a file in 2014. That was their conclusion in the negative. All to do with whether or not the discovery was new. On no planet is there a finding that there was a discovery which had become stale. A lot of talk about realization, appreciation. Revenue were aware. The revenue must have known. But the exercise of discovery is a precise one, maybe a low threshold, but it's a precise one. Now, the reason I got myself worked up over the permission application was that if you look at paragraphs 36 to 38 at page 817, you'll see in asking for permission, the revenue referred to 53 and 55. Well, what's that got to do with anything? But nowhere do they refer to paragraph 72, which shows what the Court of Appeal had actually decided. And if your lordships please look at, in fact, let me get it because I need to be responsible in how I deliver this. Yeah, if your lordships please look at 818, paragraph 4. First line, they say expressly approving and applying the concept of staleness. Well, that's just wrong. Staleness is when you found that there is a discovery, but it's bad. It's gone bad. Not that it wasn't a discovery in the first place. Now, the reason why I say that this this court shouldn't be entertaining the revenue submissions is because their application was on the grounds of staleness, nothing else. So, and if it's put to me and you show me, or Ms. McCarthy shows me that they applied it to re-argue the factual point on discovery, then I'll withdraw what I've just said and deliver an apology. But they haven't. They said it was staleness, nothing else. Now, the trouble with that is staleness presupposes a discovery. So the revenue can't run staleness before your lordships without running their case on discovery. So they've smuggled submissions which re-argues their factual case by bringing in staleness. That's why I'm saying we shouldn't be here. But that ship has sailed, we are here, but I'm simply saying that this was not a permission application that correctly stated what the Court of Appeal had decided, did not address the Court of Appeal's finding at paragraph 72 anywhere, said that the revenue looked at, that the Court of Appeal looked at staleness when it didn't, and have smuggled in re-arguing a factual case by saying it was a very important point of law to do with staleness. Now, I'm saying in the light of all that, no, your lordships shouldn't be listening to the revenue submission on discovery. And in case your lordships are thinking of doing it, on no world, in no world or no view should this case be remitted. The revenue have had every chance. Mr. Villatt, who was their counsel in the first tier and upper tribunal, he's taken silk now. And then to change their counsel. This is the prejudice to Mr. Tooth would be enormous. Just while I'm at it, a point made by my Lord Briggs yesterday, he's the only one of your lordships who's picked it up. The revenue at paragraph 123 at page 87 to 88 of the written case have advanced for the very, very, very first time a new point, which is, properly read, Mr. Tooth's self-assessment should be read as not assessing at -13, but should be read as assessing at plus 455, and then our Schedule 1A inquiry works, doesn't it? Again, my respectful submission is your lordship should give the revenue no encouragement in dicta. That's a new point, never pleaded before. First time I saw it was when I got the revenue's written case. My respectful submission is that your lordship should not encourage the revenue. And anyway, as it happens, I've shown you page 485, the tax return. It assesses at -13, so it doesn't assess at plus 455. That's another new point. I wonder, because I'm ready to move on to deliberate inaccuracy. I'm going to relegate staleness and come back to it at the end, not because it's not important, but because actually it only arises if I lose every single other point. And deliberate inaccuracy are again, although it's prosaically to do with putting a number in a particular box, the points are important. I wonder, just asking about the break, it's 11:28 now.
By all means, if this is a convenient point at which to have a 5-minute adjournment, then we'll do that now before you embark on a new topic.
Exactly. Thank you, Mama.
Very well, then. We'll adjourn now and resume in 5 minutes' time.
I'm grateful.
We're ready to resume. Mr. Ghosh.
I'm very grateful. So having spent a very long time on discovery and showing your lordships how there wasn't one. Please may I now move on to the complaints made about the tax return. Now, just about that, I'll take it in this order. First of all, was there an inaccuracy? No. Even if there was an inaccuracy, was it deliberate in the sense of intentionally trying to bring about the insufficiency of tax? No. Of course, I've got to make that good. That's the correct meaning of deliberate, but I shall. And then thirdly, even if there's an inaccuracy, even if it was deliberate, did it cause, it being the loss going into the partnership box, the insufficiency of tax? I say no, it can't, because the intention was always to assess at -13. That was the whole point of the advice given to Mr. Tooth, which you've seen at paragraphs 8 to 11 of the FTT's decision. And again, it's a promise made yesterday. This really shouldn't take very long at all. Inaccuracy. The reason we're looking at this is a combination of section 29(4), which your lordships have seen. Then separately, section 36(1)(a), that's at page 866. And actually, please, if your lordships could look at that. And it's 1a little a that we're looking at, brought about deliberately by the person. And then 118, that's at page 883. And if your lordships please look at little 5, little 6, and little 7, because little 5 and little 6, which tell us what careless, it extends the meaning, or it doesn't, that's the whole point. It supplements the notion of carelessness, little 5 and little 6. And then little 7, which is the provision the revenue rely on, that supplements the notion of deliberate behaviour. The preliminary points, 1187 that the revenue rely on was not in effect when the 31st January 09 return went in. And there was no indication of when it would be brought into effect. We were told that on the 26th of February 09, that it would take effect from 1st April 2010. But that means even when Mr. Tooth put in his amended return on the 10th of December 09, it wasn't yet in effect, but it has retrospective effect. And that's actually important, because that means it could, and I've said it already, apply to somebody who put the return in 1992. Now, there's a problem if, looking at 36(1)(a), the loss of income tax or capital gains tax was brought about deliberately. And that's, when I get to deliberate, it's not a but-for test. The loss of tax has to be brought about deliberately. Then looking at 1187 at page 883, references to a loss of tax or a situation brought about deliberately by a person includes a loss of tax or situation that arises as a result of a deliberate inaccuracy in a document. So first of all, the legislative technique has been called a deeming provision, and that's because the explanatory notes, they're behind tab 61. And the Court of Appeal, as it happens, focus more on the wording of the explanatory notes than 1187. The legislative technique here is not deeming, it's not treating something as X which isn't X, but rather to be Y. I mean, there are examples all over the place in the tax code. Shares are sometimes treated as loans. and the draftsperson says, for the purposes of the tax code, these shares shall be treated as loans. The legislative technique here is that it's inclusive. It's saying, in the context of section 29(4), and more immediately in the context of section 36(1)(a), the notion of something brought about deliberately includes, if you interpolate 1187, a situation that arises as a result of a deliberate inaccuracy. Whereas deeming replaces one word with another, this is doing something different. It's supplementing 36(1)(a). So colour is given to the notion of a deliberate inaccuracy which has a result of a loss of tax by the notion of bringing something about deliberately. Now, is there an inaccuracy? Well, no. The revenue would have it that if Mr. Tooth had submitted a paper return and he couldn't because it was too late, and he'd scratched out partnership loss and written in employment loss, that's fine. By putting it online as an employment loss and explain a partnership loss and explaining that it's an employment loss, that's not fine. And my response to that is, it's not a game. This triggers time limits, and the non-rhetorical question here is, why should Mr. Tooth assume that the machine that's reading his return can't read the box? I mean, what's it doing there if it's not to be read? The revenue say, oh, well, look, not that bad, because you could have put in a return and incurred a £100 penalty. I call that submission disgraceful. I think it is. They said, secondly, he could have written in separately, like Mr. Cotter did. Well, why should he? He didn't want to. He wanted to put it in his tax return. Thirdly, they said, well, you could have put it in a separate tax calculation. That's the first time that point's been made. It's been nowhere said before. But again, say he didn't want to. There's quite a chilling submission made by the revenue, which is, look, we make the forms. Look at section 113. If you can't submit your tax return the way we tell you to, because you disagree with how the tax code operates, that attracts all sorts of time limits. Really? Lord Justice Males in the Court of Appeal, paragraph 110 at page 173 says, oh, but the references to an inaccuracy in a document, not in contradistinction, I suppose he must have meant not an inaccuracy of the document as a whole. That doesn't get any of us anywhere. The question is there an inaccuracy in Mr. Tooth's document when he says, here's a loss, it's in a box called partnership loss. I've told you it's not a partnership loss, it's an employment loss. Why isn't that the same as scratching out the word partnership and putting employment? The revenue rely on a case called Hargreaves at tab 24. At page 1469, I literally don't understand. It's not a figure of speech. I just literally don't understand what they're trying to say. So I can't say anything about it. They say they cite it as authority for their proposition that if the revenue makes a discovery assessment on the basis of a deliberate inaccuracy, they can also use that to attack, as it were, innocent other entries in the assessment that they disagree with. Well, no, that was a submission made by counsel for the taxpayer for his own purposes, not endorsed by the Court of Appeal. So that proposition is wrong. If the court's interested in giving guidance on something that's got nothing to do with this case, then I would say that you can dispel that myth. But there's no inaccuracy, simply because partnership loss was explained as being not a partnership loss, as an employment loss. The box wouldn't let him do it. Deliberate. Now, this is where I come to the notion of brought about. It's not a but-for test. 1187 tells us that we're in a world where it's been included, a deliberate inaccuracy in a document. And the question then is, oh, my Lord Legate.
Isn't subsection 7 simply saying that you don't have to intend the loss of tax? That doesn't have to be deliberate. It's enough that you intentionally put an inaccurate, make a document inaccurate. The inaccuracy has to be deliberate, and it causes a loss of tax.
No, I think that's what the revenue is saying. It says, and the consequence of reading it that way is that it's easier to be deliberate than it is to be careless. That's point one. And that was a point raised by my Lord Reid yesterday. And so you could read it that way, but I'm saying that's completely wrong to read it that way because it leads to an absurd result.
Is that right? If you give the broad, if you take the document as a whole, I mean, on your case, you still have to show that the document as a whole contains a deliberate inaccuracy. That's quite a strong thing. All you don't have to show is that the loss of tax which that caused was also intended.
You could read it that way, but that's why I made the point that it's that the linguistically, if one interpolates 1187 into what section 36 1a, how it would go would be you can have this assessment if the loss of tax or income tax or gains tax is brought about deliberately by the person, which includes a loss of tax or situation that arises as a result of a deliberate inaccuracy. The question is whether that second interpolated deliberate is given colour by the first use of that word deliberately to do with the tax being the loss of tax being deliberately brought about. So I'm not saying you can't read it in the way that my Lord Legate says. I'm not saying that at all, and I don't say that. What I'm asking.
Well, what do you say that it adds? That wouldn't be there otherwise.
What it adds is that it makes it clear that 36(1)(a), when it talks about an assessment which involves a loss of income tax brought about deliberately, also covers a situation, and I'll show you why this matters. So again, this won't be a silly conversation, which involves a deliberate inaccuracy, which brings about a loss of tax deliberately. And the reason that matters is if your lordships look at, it's behind tab 16, it's the penalty provisions in FA 2007, Schedule 24. And they're all to do with penalties specific to inaccuracies in documents. And so paragraph 1 at page 906 tells you, well, you've got a penalty if you've got an inaccuracy in a document. Paragraph 3 at page 911 says, look, an inaccuracy in a document is either careless or deliberate, and they've defined those. And then paragraph 13 that's at page 930. That's all to do with an assessment for a penalty for an inaccuracy in a document. And 13 sub 3 at 931, that gives you the time limits. It's all to do with an assessment of a penalty. And this is the point. This is the answer to my Lord Legate. That's all triggered by a decision correcting the inaccuracy. Now, what the explanatory note says is, look, we were fussing as to whether a discovery assessment, which doesn't on its terms correct an inaccuracy in anything, it just recovers the insufficient tax, whether that would also be properly thought of as correcting an inaccuracy. And it's to get the time limits aligned that 1187 is brought in. It's not to give a new a substantive meaning to the word deliberate. You'll find that, my lords, at behind tab 61. I'll give you a page. 157 to 180. Now, what the Court of Appeal did when they read the explanatory note, they dismissed it. They said, "Oh no, my submission's very silly." It was everything to do with giving deliberate a new meaning, because it uses the words treated as. It treated a deliberate inaccuracy as something brought action which was brought about deliberately to bring about a loss of tax. Yes, my Lord Briggs.
I'm sorry, Mr. Ghosh, could you give me that page reference to the explanatory note again? I seem to have got it wrong.
Yes, of course. 157 to 1957 to 1980.
Thank you.
So, what the Court of Appeal said is, treated as, that's a deeming. But they ignored the rest of it, which is the explanatory note made it clear in terms that it was to do with time limits for Schedule 24 penalties. And that's at page 1964. So the answer to my Lord Legate's question is, well, what's the point of 1187? And indeed 1185 and 6. It's all to do with permitting a reader to read that a discovery assessment as also correcting an inaccuracy. That's all. Otherwise, we do have the absurdity of it's easier to be deliberate than careless. And just about that, Ms. McCarthy took you to a case called West, and it's tab 48. Now, I'll tell you what West was about. West was where the taxpayer didn't want to be fixed with a tax liability. He wanted the liability to be fixed on the company. So although the company didn't make a payment, it couldn't make a payment. He said, I'm recording the company is making a payment. There's a tax liability, but it's not on me, it's on the company. The company made a deduction of income tax on this payment, which I'm recording, but it didn't make, it couldn't make. And that means liabilities on the company, you can't get it against me. That's what the case was about. And what the upper tribunal, what Lord Justice Voss and the judge said, and this is at paragraphs 63 to 66 at page 1589 to 1590. What they said was, well, you might have thought that just by recording a payment which a company didn't make, the law was that, well, it's treated as making a payment and then the PAYE liability is on the company and not you. You might have thought that. That doesn't stop you being willful. Why? Because you knew the company hadn't made a payment. So it is not, on any view, authority for the proposition that putting a number in the wrong box without an intention to bring about a loss of tax counts as deliberate behaviour. This was a case where the taxpayer knew there had been no payment, recorded that there'd been a payment, and there'd been a deduction, none of which could have happened and said, oh, well, I thought the law was that this all worked. So having said there's no inaccuracy, I say, and what's more, that it can't be said to be deliberate. You can have a linguistic debate as to whether it can be read in the revenues way or in the way that I say is a sensible way. But here, again, because it's not a game, to treat a taxpayer, and bear in mind 1187 is retrospective, to treat a taxpayer as having brought about a deliberate loss of tax makes no legislative sense. The revenue don't need that protection and shouldn't be given that protection. And of course, these points bleed into each of these points bleeds into the other. There was no inaccuracy because he made it clear it wasn't a partnership loss, it was an employment loss. He didn't intend to bring about a loss of tax. And here's the thing, the fact that the number of minus 13 was spat out rather than the figure of 455, which is the figure the revenue wanted. And here I'm coming to cause. Why is that Mr. Tooth's problem? He wanted to self-assess at minus 13. And he did that on the basis of a perfectly accurate document with no intention to mislead. And what that loss, and this is again a function of evidence, in order for this causation to bite, the revenue say, it's because putting the loss into this box rather than any other box, even another wrong box as it were, caused the wrong number to be spat out of the software. Minus 13, which is what Mr. Tooth wanted, rather than 455. Given that Mr. Tooth's advice was that minus 13 was the right number, and the revenue are not attacking the minus 13 as an inaccuracy, they're attacking the box, partnership box as the inaccuracy. He wanted, because he was advised that the correct number was minus 13. So putting a number in that box, it would have to be a function of evidence as to whether if Mr. Tooth had been told, well, that's going to spit out the wrong number, Mr. Tooth, whether he would have done something to make sure that the number spat out was minus 13. That was his advice. The correct number isn't 455. If somebody tells him it's 455, that's a wrong answer.
Mr. Gosh, can you just help me on how in practice that would work? Suppose that he filled in the form without putting a number in the partnership box, but did everything he wanted and was advised to do in the white spaces. So when he got to the figures, it spat out what in his view was the wrong figure, namely plus 455,000. What would he do on an electronic tax return to correct that and assert his own intended self-assessment of minus 13,000?
I think if you wanted to do it on the online return in the way that he did it, you would have to put in a second return, but putting the figure in a different box that gave the right answer and explaining why he did it. In other words, exactly what he did do. It was happenstance, but that's the only way you could do it. The other ways you could do it, to write to the revenue, I suppose, and say, it spat out 455, you should take it, that that's not the right answer. I am self-assessing at minus 13. And you should read my self-assessment as minus 13, not 455. Please, my Lord Burrows.
Yes, can I just be clear exactly what you're wanting us to read deliberate inaccuracy as meaning? Are you saying the same as you say at paragraph 76 of your written case? There you tell us that it must refer to an inaccurate representation that the giver of the document intends HMRC to rely on as accurate.
Yeah,
And then
I'm saying that.
you've got a couple of sentences after that. You've mainly talked so far about with an intention to bring about a loss of tax in your oral submission. Are you indicating that they are the same, or which is the precise way you want us to read this?
I'm saying that the deliberate inaccuracy, if that's what you're finding, needs to be one that intended to bring about a loss of tax. In other words, intended that the assessment was insufficient, wrong. Imagine this, forget this case. Yeah, I thought a payment was deductible. It's not, say, the revenue. It's a pure technical point. I'm going to claim it on my tax return on the footing that it is deductible, and I'll let the revenue know I've done it. That's all Mr. Tooth has done, and there's no deliberate inaccuracy. Here, Mr. Tooth is told the law is that you can, if you have this employment loss, you can reduce an earlier year's loss by self-assessing. I'm saying textually 1187. If you interpolate that into 36(1)(a) and section 29(4), because they talk about a loss of tax brought about by a taxpayer, that A gives colour, because deliberate then on that interpolation is used twice. And it's inclusive, it's not a deeming, it's saying something brought about by somebody includes that same something brought about by somebody by way of a deliberate inaccuracy. That's inclusive. That's what I'm saying. I'm saying that. That's the difference between an interpolation and a pure deeming. And does it make sense? And that's the point. Does it make sense? Yes, because otherwise it's easier to be deliberate than it is to be careless. And this notion that you've been presented with about the who bears the risk of putting in a figure in a box that you know is wrong for 20 years, even though we've explained it to be correct. Well, if you unpack that and say, what's the correct policy that underpins 1187 compared to 1185 and 6? The correct policy is that deliberate means an intention. Deliberate means you're doing X when you know it's not X, it's Y. He didn't do that. He put X into that box and then explained it was Y simultaneously. That's why I'm saying the points bleed into each other. It's not a chronological point. If I scratch out a partnership first and put employment and then I write the answer in, that's okay. That's not deliberate. If I put the loss in first and then chronologically explain that it's not a partnership loss, that's an employment loss, that's not okay. That's deliberate. That's an extraordinary proposition. Anyway, oh yes, my lord.
And do you accept that it's what I think was said by the upper tribunal as tantamount to fraud?
I really don't have to go as far as that, because I don't want to paint myself into a corner to say it's tantamount to fraud and then have to face questions about, well, how can you say that? I'd say something which is tantamount to fraud clearly is deliberate, but it's a conscious decision to make an inaccuracy that to give rise to an insufficiency of tax which you are bringing about. My lord, Lord Legate.
Quite a small point, this, Mr. Ghosh, because there are not likely to be many situations, I would have thought, when someone deliberately makes their tax return inaccurate without wanting to pay less tax than they should have done. But nevertheless, if it was interpolation works in the way you say it works, wouldn't it have to say arises as a deliberate result of a deliberate inaccuracy? Because the words, when interpolated, don't require, do they, there to be that the consequence has to be deliberate. Only the inaccuracy in the document has to be deliberate.
It could have been plainer. Yes, it could. But I'm saying to not give rise to the what I've really submitted are the daft consequences of any opposite reading, where it's easier to be deliberate than careless. One interpolates it and says the word deliberate and deliberately are given the same colour, the same meaning. So whether one takes that interpolation and say, well, that's how you get there, or one does a little bit of linguistic carpentry, I don't really mind, precisely because it's not a game. So that's why I say inaccuracy, no. Deliberate, no. Did it cause this insufficiency? No, because that's the answer that Mr. Tooth wanted, minus 13. And these are big points. That's the lot on the return. Going back to staleness, I wonder if I can do this. I've got about 7 minutes left, which I think I can just about do. Please may I ask your lordships to do two things. Please may you read Charlton. It's page 1318 to 1319, paragraph 37. And then, oh, well, if you let me know when you've done that, then I'll take you to Patillo.
I'm sorry, I must have taken down the reference wrongly. Can you give us the reference to Charlton again?
Of course, my lord. It's tab 37, page 1318
Oh, thank you.
to 1319, paragraph 37. Please may I continue? And then please may your lordships read Patillo paragraphs. This is slightly annoying because it'll take time, but it'll let me make my submissions short. Paragraphs 46 to 53 at page 1492 to page 1495. Please may I continue? I'm very grateful. My Lord Briggs, please may I continue, or should you need longer? Thank you. All right. What do these two passages tell you? There's a difference between discovery having to be new, and separately, if there is a discovery, everybody knows there's a discovery, it can become stale. Why? This is the so-called if point. I'm taking the two passages together. what the upper tribunal is saying, if you combine the thinking in Charlton with the thinking in Patillo, is that the assessment, the discovery assessment in section 29, its causative event needs to be the discovery. That's what if means. And then separately, which is to do with the sentence saying, well, oh, and what's more, why on earth should the revenue be able to sit on its hands and then suddenly whip out a discovery assessment? That can either be an extension of, look, the discovery has to be caused, the assessment has to be caused by the discovery, or it can also be a separate overlying public law control, the sort of approach taken by the upper tribunal in Anderson that we saw. Now that actually deals with, first of all, the textual points. If you read the VAT legislation, they specify time limits. Doesn't staleness make the time limits given in section 36(1)(a) a waste of ink? Well, no, it doesn't do any of that. But what it says is, this notion of staleness, the causative event has to be, for an assessment, the discovery. Otherwise, the discovery is the assessment, and the assessment is what fructifies the discovery. The discovery by itself is hopeless because it doesn't do anything in the tax code. The discovery is no longer assessing something new. And that's why all of the submissions to do with, well, this is JR through the back door. No, it's not. I promised my Lord Legate yesterday that I'd come back to this point, because my Lord Legate said, well, look, can't the discovery provisions and the inquiry provisions coexist quite happily side by side? So why shouldn't the revenue have optionality? Answer, the assessment plus self-return plus inquiry plus closure notice process, that's what's supposed to give the taxpayer finality. That's point one. Optionality in the sense of deciding not to raise an inquiry, but say, do you know what, I'll let them, well, for whatever reason, I'll whip out a discovery assessment later, undermines that finality. So you really don't have to go there about any angst on the JR through the back door. It isn't. It's saying an assessment and a discovery go together. They have to go together because a discovery without an assessment is meaningless. That's why the kind of soundbite in the FTT case is about it's the discovery that has to be new, not the assessment. They don't make much sense. It's a good soundbite, but discovery and assessment have to go together. So the concern on staleness is, if you leave it too long, why should we assume that the causative event is the discovery for the assessment? And that accommodates the discovery being kept fresh. In other words, showing that the causative event is discovery. Ms. McCarthy said, well, look, you get some absurd results because that means a genuine, proper discovery made by somebody who didn't know before. Taxpayer is surprised by the discovery assessment. You've got a discovery made years before. Same taxpayer is surprised by the same assessment, but even though the discovery had been made before. Answer, because a discovery is a subjective test, you have to find an identified officer who's made that discovery. The revenue are being held to account by this notion of staleness. That's what this notion of staleness, the if analysis, is doing. is holding that officer to account to say, you need to be clear that the causative event for this assessment is the discovery. It's a control. It also deals with the textual points made that 36(1)(a) talks about an assessment may be made at any time. The assessment we're talking about is the discovery assessment, so we're actually thrown back onto section 29. So the if point is still there. And this will not cause chaos because the revenue work in teams. The revenue are in a place where, as I say, one revenue officer can continue a process started by another revenue officer without any problem, and one of them will make a discovery. Or you're in a place where one revenue officer can delegate, just as I say, what happened in this case under 1131B. Fanciful examples of somebody dying without telling them, anybody else, that they've made a discovery, that can happen in any walk of life because somebody hasn't done their job. That's not Mr. Tooth's problem. Please may you just give me 1 minute, literally 1 minute, to check with my junior that there's nothing I've missed. It'll be slightly embarrassing if it tells me that I have, but I'll wait and see. No, and just in case your lordships need to know, of course I adopt everything I said in my written case. Those are my submissions.
Thank you very much, Mr. Ghosh. Well, we turn then to Ms. McCarthy for her reply. Ms. McCarthy.
Thank you, my lord. If I may start off with my learned friend's submissions on the deliberate inaccuracy issue. Taking it in stages, on this issue, it's common ground that the correct approach is the three-step inquiry. Is there an inaccuracy in a document given to HMRC? Was the inaccuracy deliberate? Did the inaccuracy bring about, i.e. cause the assessment to be insufficient? So starting off with the first stage, was there an inaccuracy in a document given to HMRC? Please can I start with making a preliminary point? In a number of exchanges yesterday, there was an assumption which underlay some of the questions that were being put, namely that the document here, so the return here given to HMRC was, when viewed as a whole, accurate. Now, just to be clear about this, on any view that assumption is wrong, and that is because we know that in law, -13 is too low a self-assessment. So that's common ground, and at no point before this court or the courts below has Mr. Tooth sought to suggest that -13 accurately reflects his liability to tax for that year. And we know that the correct amount he should have self-assessed is 455 because it's common ground that Roman Gate failed. So whoever succeeds on the deliberate inaccuracy issue, the one conclusion that isn't open is that the return read entirely as a whole was accurate because Mr. Tooth's own position necessarily entails that there is an insufficiency. And that's because if there's no insufficiency at all, then HMRC would succeed under the Schedule 1A inquiry and Mr. Tooth would have a Pyrrhic victory. Now, my learned friend says, I'm saying this for the first time before the Supreme Court, that's factually wrong. They were submissions we made before the Court of Appeal. Now, to be clear, HMRC is not suggesting that -13 is of itself a deliberate inaccuracy. So I just want to be clear about that. My learned friend said in his submissions that we're not attacking -13 as the inaccuracy. So yes, that is right. We're not attacking it as being the relevant inaccuracy. HMRC's position is we don't need to rely on -13 itself being a deliberate inaccuracy because we get home as a result of section 1187. But the only point that I want to make is that the return on any view is wrong, contains an inaccuracy because of that figure. And that's not cured, and this is important because of what my learned friend took the court to. That's not cured by the fact that Mr. Tooth genuinely believed -13 to be accurate, so he made a correct declaration, because then take this example, say I simply accidentally, because I don't check very well, miss dividend income out of my return. Clearly it's a case where I should be susceptible to a penalty. My learned friend has shown the court the penalties regime, and both careless and deliberate concern inaccuracies in documents. And I clearly in that case can't be saved by saying, well, my return is not inaccurate because I believed it to be right. So the focus here at this point then shifts to what is the true debate, the discussion about how the partnership pages as a whole should be read, and whether those entries as a whole should be interpreted as inaccurate or accurate. So taking that in stages.
I'm just wondering, doesn't your argument, your argument seems to be that if the self-assessment is in the wrong figure, that's an inaccuracy, and it must be deliberate because it's the taxpayer who makes the self-assessment.
No. So my lord, we accept that. So we accept that when Mr. Tooth filed his self-assessment as -13, he did not intend and did not know that -13 is wrong.
Yeah.
And we say that because of section 118 sub 7, that doesn't matter. So he made -13 is of itself inaccurate. We are not saying that Mr. Tooth knew it to be inaccurate. So we are not relying on that as the focus of the deliberate inaccuracy argument.
But if you say that that is a deliberate inaccuracy, I mean, you are saying that, aren't you?
No, my lord, I'm not saying that Mr. Tooth intended -13. Sorry, I'm not saying that Mr. Tooth knew -13 to be wrong.
Are you not saying that the inaccurate self-assessment at -13 rather than plus 400 odd thousand in itself satisfies the requirements of section 1187?
No, I'm saying only if we can point to other deliberate inaccuracies, which when you apply the rest of the test, lead to the causative end product. So that is important.
So
yes, my lord.
So you are saying, I think, that you can put right by a discovery assessment an innocent inaccuracy if you can find some other deliberate inaccuracy in the document, and construct some kind of causative link between the deliberate one and the innocent.
Well, the innocent inaccuracy is merely the insufficiency in this case. So put another way, we are not saying that the insufficiency has to itself be deliberate, and we're saying that's the function of 118 sub 7. And there is then a separate argument as to whether we're right to say that the other inaccuracies were intended, and whether we're right to say that there's a causal link. But those, just to be clear, are separate points. So at this point, the focus then shifts to the status of the entries in the partnership pages, and the debate is as to whether those entries were inaccurate. So if I may just take this in stages, we know that taken at face value, the numerical entries, so just the numerical entries in the boxes, were wrong. So if there was no white space commentary at all, then plainly the partnership pages contained inaccuracies. And I think even my learned friend would accept that, because he is saying his submission is that his white space explanation in box 30 made the partnership pages taken as a whole correct. So what this court is having to do is analyse then the effect of the explanation that was given in white space box 30. So for the partnership pages to be accurate, box 30 needs to have the effect of, we say, changing all the headings on those pages and all the labels above the boxes so that they're not interpreted as referring to partnership losses, but as employment losses. And we say this because if the effect of box 30 is anything less than that, then the information contained in the partnership pages is wrong, albeit it is accompanied by an explanation as to why it is wrong. Now, in our submission, the explanation given in the white space is not capable of having that effect. And that is because Parliament has given to HMRC, as the tax collector, the authority to prescribe the form of the return in section 1131, and to prescribe, and I quote, what constitutes an electronic return, and that's section 81H. So our position is that taxpayers are not permitted to change the headings in the return because those headings, i.e. the form of the return, have been prescribed by HMRC. So it isn't permissible for the taxpayer to provide his own document to HMRC in response to a notice to file. And indeed, it isn't permissible for the taxpayer to change the form of the document that HMRC has provided. Yes, my Lord Legate.
The effect of your submission seems to be that HMRC, by the way it constructs the electronic return, can force someone to make an inaccuracy, which it's impossible to correct, however open and transparent they are, and thereby trigger the 20-year time limit for any inadvertent mistake that may happen to be caused.
So my Lord, I'm coming on specifically to address your Lordship's question, and I will deal with that specifically. We say that it's essential that the authority that Parliament has given to HMRC is properly respected. And that is because in the real world, there are literally millions of self-assessment taxpayers. HMRC must be able to set up systems and forms of returns which can be dealt with through an automated process. And that is to ensure that the tax management system is efficient and effective. And that system would fall apart quite simply if it was open to every taxpayer to chop and change the form provided.
But the difficulty is that if you design the electronic software in a way which prevents anyone from completing their self-assessment otherwise than in accordance with the revenues view of the law, then I'd have thought you might well be in breach of the failing to enable people to comply with their statutory duty to make a self-assessment.
So my Lord, I'm coming on to deal with that because I think that is not the same, but if I may, a similar question to my Lord Legate's question, which is to say, how can they truthfully sign the declaration if they don't believe the information to be correct? So I'm coming to that, if I may. So, in order to assist taxpayers in making complete and correct self-assessments, we would say that it is right that the system is set up to calculate an assessment which reflects HMRC's understanding of tax law. And pausing there, that is precisely what Parliament has prescribed. Moreover, in this case, the form prescribed by HMRC did in fact reflect the correct view of the law, were it not for the fact that Mr. Tooth had filled out the partnership pages, the self-assessment would correctly have shown 455. Now, the fact that it is for HMRC and not Mr. Tooth to prescribe the form of the return is critical when it comes to characterising the effect of the explanation given in the white space, we say, because a tax return is not a document like a contract where both parties input into aspects of the drafting, and equally it is not like a letter where only the letter writer sets the form of a letter. Here, Parliament has prescribed that HMRC and only HMRC can set the form of the document. And I'm coming on to the point about the truthful declaration and the ability to self-assess. So we say, against that background, it's not possible to treat the explanation in the white space as overwriting the labels that the revenue have prescribed, since Mr. Tooth doesn't have the authority to do that. Rather, we say the way in which the explanation has to be characterised is as an acknowledgement that those entries are incorrect and an explanation or an excuse, if you like, as to why that is so. Now I'm coming on to Mr. Tooth's own responsibilities. Mr. Tooth's obligation is to make and deliver a return in the form prescribed. So pausing there, if he freehand wrote on a page various information and said, this is my tax return, and headed it up tax return, and he posted that, that's clearly not appropriate. That's not in the form prescribed. So first of all, his obligation is to make and deliver a return in the form prescribed. What follows from that is it's not open to him to make amendments to the form, i.e. the format, the labels of the return. Then we come to the twofold further obligations. One is for him to make a self-assessment, and two is to sign the declaration, so just for your note, it's page 460, that says the information I have given on this tax return is correct and complete to the best of my knowledge and belief. So they're his two further things that he's required to do. Now we say that neither of those requirements in fact gives Mr. Tooth any problem. Taking this in stages, we know that if Mr. Tooth had not filled out the partnership pages, then a figure of 455 would have appeared in box 1 on the tax calculation summary page. Now, his position is that he believes that figure is wrong, and he believes his self-assessment is to be minus 13. So pausing there, just at that point, Mr. Tooth would say, well, I can't simply file this document as it stands because, okay, there's a figure in box 1 which is apparently my self-assessment, but I don't feel comfortable signing the declaration because I don't believe that to be complete or correct. Now, it was suggested that this would prevent Mr. Tooth from signing the declaration, but and this is important, there's nothing whatsoever that prevents him from entering that self-same explanation simply in the white space on the tax calculation pages. That would then let him make the necessary declaration, because at that point, he has entered the explanation. He has made the declaration. He hasn't metaphorically taken a red pen and fiddled around with the form of the return. So the argument that I've been faced with is, yes, but why is it that Mr. Tooth can't rebadge the partnership page entries? Why can't he simply do exactly that and explain it away? But we're saying that why can't he simply look at what the return completely, correctly completed provides, and if he thinks that is wrong, explain why. So we are saying that the effect of that explanation is a separate and different question and not before the court, but that would let him submit a return which A, contains a self-assessment, and B, as a whole, he believes to be correct and complete because he's explained the position. Yes, my Lord Wardsells.
Yes, I'm struggling to see how that gets you out of your problem, because the box showing his self-assessed tax would then, on this theory, be inaccurate. And yet your account seems to involve him using the text in the white box to explain that the figure should be different. And on the basis of the white box explanation and his assertion that the different figure is right, he can sign saying that the form is true and accurate. But isn't that exactly what he tried to do, but by reference to giving an explanation in relation to a different box, which was inaccurate, namely the partnership pages. So you change the partnership boxes in order to produce the right figure from his point of view in box one. But you seem to be saying, well, he could have left all the partnership boxes alone, get the wrong figure in box one, and then explain that wrong figure. I'm just struggling to see why there's a difference in principle between those two.
Yeah. So I think I'm right in saying that certainly my Lord understands the point that I'm making. We simply say there's a difference between the two approaches because Parliament has chosen to prescribe the form of the return to HMRC. So we say in HMRC's formal position is that it is for any taxpayer to complete the form of the return correctly. We also say that it would...
So, I'm sorry to interrupt you there. It probably is my fault, but I'm not following how that helps you, because the form says the amount of self-assessed tax should appear in box one, and on your theory, the wrong figure appears in box one, but you explain it away in the white box.
No, so it's important to be clear. Box one is automatically corrected. So box one is a product of filling out the form correctly. Box one is automatically calculated. Mr. Tooth would say.
Forgive me. So what? I mean, the form prescribes that the amount of self-assessed tax should appear in box one. That's what the form prescribes. It may be automatically generated, but that's Mr. Tooth's problem in this case, that he's entered figures which show a wrong figure in box one, which is the prescribed place in the form where you say what your self-assessed tax is. What do you do then? According to you, you write in the white box to explain that the answer in box one is wrong.
Well, yes, and my Lord, the reason we say that is so is because it's simply not workable or practical for 12 million self-assessed taxpayers each year to disregard the headings in the form. And so we say that it is a distinction with a difference, because then you're not interfering with the form. You're not trying to cross out headings and make new headings. You're not interfering with the form of the return. Rather, what you are doing is adding additional information in the white space so that you can sign a truthful declaration and send it in. And that's our submission as to why the form of the return must be respected, and why it would be appropriate then to read the tax calculation pages as a whole to say, well, as a whole, there's clearly no deliberate inaccuracy there, because in that scenario, we would accept that he has no option, he has no control over the box one figure. That is forced upon him, because that's the product of the software, that's the way the calculation works. And in that situation, he would correct the thing that's forced upon him in that way. So I am conscious that I do have other points that I need to get through,
Right.
and
Thank you
I
very
appreciate that.
Before we leave that point, I think I may be, apart from yourself, Ms. McCarthy, I think I may be the only other person who took part in the Derry case. And you'll recollect, we went over this in Derry, and at the end of the day, the court didn't decide this point, but it expressed a good deal of skepticism about the idea that the box one, that effectively the revenue by using software which generates the box one figure can prevent the taxpayer from claiming relief to which he believes he's entitled in accordance with Section 9, even if at the end of the day his belief turns out to be mistaken.
So, my lord, just
sorry, just for the sake of others, so we'll have a note of it at least. We dealt with that it's addressed in Derry. It's at page 160, and it's in paragraphs 64 and 65, and that is touched on.
So the point in Derry was that in Derry, Mr. Derry's return showed in box one the equivalent of 455. And so in Mr. Derry's case, as a matter of law, share loss relief could be carried back, that 455 was interpreted as a self-assessment for -13 because of the explanation in the white space. So my lord,
I wasn't concerned with the fact, but the revenue's argument that it effectively can use the software so as to prevent people from making Cotter claims using electronic forms, Cotter compliant claims, was not ruled on because the court felt it hadn't had enough by way of submissions and indeed evidence on the point. But skepticism was expressed by the majority of the court.
Yes, and so we would submit that we would submit that this would be as an example. Sorry, my lord, may I just confirm? The only point that I need to say is that this would not be any sort of deliberate or intended inaccuracy, completing the form in that way, because that would be a genuine example of where something has been forced on Mr. Tooth in order to sign in order to sign his declaration. Mr. Tooth then would need to put in an explanation to make his form complete. And I think it is as simple as us saying, ultimately, it would make the tax system unworkable if taxpayers were willy-nilly allowed to cross out headings, because the right way of dealing with a format problem is simply to put the explanation in the white space. Yes, my lord, Lord Briggs.
Can I just follow this through? Remembering your submission yesterday about what the revenue computer does or doesn't read in one of these forms. If he had filled in the form in the way you suggest he should have done it, putting 455 in box one and then putting in a white space somewhere, by the way, I think that's 30, he'd presumably get a tax bill from the revenue for 455.
So what would have happened in that situation? Well, can I just be clear? There's a separate question as to what would be the effect of a taxpayer having done that.
Yes.
And that is a question that is not before this court because it's not what Mr. Tooth has done. And as my Lord Reid, I think, suggested in Derry, we should wait until there's a proper case where that is the actual issue. Except
that I'm entitled to ask you, aren't I, as counsel for the leading counsel for the revenue, what the practical consequence of your submission is. And I thought you said yesterday that the reason why the revenue is so upset about this case is all its computer actually reads is box one and doesn't read the white spaces. And therefore, my natural, perhaps simplistic conclusion is that if that's what the taxpayer has done, although he wanted to self-assess at -13, he'd get a tax bill for 455.
So what would have happened if HMRC had done that and the system had worked in that way is HMRC would have treated the white space entry as a claim outside the return. If Mr. Tooth disagreed with that treatment, then he had the right to challenge HMRC on the treatment as Mr. Cotter did. And in fact, in common with Mr. Cotter, HMRC's treatment would have been found to be correct. So those are my instructions as to how HMRC factually would have dealt with it. I appreciate it's not for me to give evidence. Yes, my Lord Legate.
Just tell me if you would, does HMRC have a power if somebody fills in the tax return it thinks wrongly by scratching out a heading and writing something else and rejecting it as an invalid or return?
Yes.
I mean, if somebody just sent in a bit of paper that's
yes.
something, or if they messed around with it too much, can it be
Yes.
rejected as invalid if they don't take measures up as a proper tax return?
So that's two separate questions. If, for example, Mr. Tooth had simply longhand tried to design his own tax return, then the revenues would say, what is this piece of paper you've sent us? It's not a tax return. Okay. Now, turning to the paper return alternative, by the way, it's not our submission that Mr. Tooth could have submitted a paper return and scratched out the headings. That's not what we said. So I think that's been a misunderstanding. What he could have done if he'd completed a paper return was enter freehand -13 in box 2. So alternatively, if he was simply not happy submitting the electronic return, which said 455 in box 1 plus an explanation, that is what he could have done. Now, HMRC's position is that if the taxpayer does not agree with the calculations provided by the prescribed electronic form, then that is the correct approach that a taxpayer should take. Now, it so happens that Mr. Tooth's paper return would have been late, but it remained an available approach. I might have made a flippant comment about, well, it would have only cost £100 yesterday, but in the real world, it's inconceivable that if HMRC was told by a taxpayer, the reason that I'm filling in my paper return and sending it to you late is because I honestly tried to complete an online return, past the paper return deadline, but I couldn't because there was a software problem, he would not have to pay £100. That's in the real world. Now, I've also obtained instructions as to what would happen then. So that's my Lord Legate's question. Had Mr. Tooth submitted a paper return with an amended tax calculation figure, so the -13 figure, then what would have happened is HMRC would likely have corrected that figure under their power in section 9ZB, because HMRC on receiving a return simply have the power to send it back if they think that there's a correction that needs to be made. So in the paper return scenario, that is what HMRC would have done. And HMRC's position is, again, I say it again, because of 12 million taxpayers, if a taxpayer wants to do something special or different that does not fit in the four corners of the prescribed return, then what he has to do is submit a paper return so that HMRC can actually see it. What he can't do...
That submission was rejected by this court in Derry. We maybe do need to look at from page 1680, paragraph 65, about halfway through the paragraph, Lord Carnwath, with whom all the justices apart from Lady Arden agreed, says of a revenue submission, it implies that by prescribing an online form, which makes it impossible to make the necessary adjustment to the self-assessment figure, the revenue can deprive a taxpayer of a relief to which he is lawfully entitled, which at the time when Mr. Tooth put in his return, he believed he was. If you can't turn on whether to which he is lawfully entitled and to which a claim has been clearly included on the face of his return. That cannot be right. Then there's a 12 million taxpayer point. It may be, as Mr. Dean, who was a revenue witness, seems to be saying, that it would have bypassed revenue's automated tax consistency check. However, that's not the fault or the concern of the taxpayer.
But the important distinction between well, it's not even this case because that's not what Mr. Tooth did, but this hypothetical example in Derry is that in Derry, the return was depriving Mr. Derry from the opportunity to submit a self-assessment that was actually correct in law, because that was how the tax code operated, not simply what he believed to put in.
But on your submission, the same would have applied if Mr. Tooth had in fact been right about the tax scheme working. He would still have been unable to put in a return claiming that relief in a way which would have met the Cotter requirements. He couldn't, in other words, have filled in box 1 in the correct way.
But my lord, if Roman Gate had worked in the way that the Derry scheme worked, we wouldn't be here because there wouldn't be an insufficiency in the return.
I think you're missing my point. I mean, Lord Farnworth actually, again, it's quite relevant what he says at the end of the previous paragraph, last sentence of paragraph 64. The revenue's case rests on the assertion that the process of self-assessment is defined by the figure that appears in box 1, and that other claims are irrelevant insofar as they don't feed into the self-assessment for the current year. And that's really it. I mean, that's really the problem that any taxpayer would have if he was trying to claim a relief to which he believed he was entitled, and which he might turn out in law actually to be entitled to, but which he couldn't get into box 1.
So I think, my lord, if I can just bring it back to perhaps the facts of what happened in this case, I think the simple submission that we're making is that the effect of the explanation cannot be to have put a line through all the words that said partnership on the partnership pages and to have written the word employment. That's ultimately, that's our submission. And so that is why we say that it's not right to interpret the boxes essentially I'm sorry. It's not right to say that those boxes were accurate, because what that would mean that Mr. Tooth has been allowed to do is play around with the format of the form. I am, my lord, I am conscious about the time. And so I think what we would then say in relation to deliberate is that if minus 13 is the only inaccuracy, that obviously isn't itself deliberate. If it is accepted that the partnership boxes are inaccurate, so if it is accepted those boxes are inaccurate, then we would say that the explanation simply demonstrates that Mr. Tooth appreciated it. We would point to West to say that Mr. Tooth does not have to intend the legal consequences of his actions. And in relation to simply the brought about test, we would say that that's a functional test. Again, the legal consequences don't have to be appreciated. Section 1187 must have some role to play, because on my learned friends analysis, we say it's devoid of any meaning altogether. What I would like to do, if it's okay, my lord, is move on to discovery, because we do have some important points that I do need to cover in the last few minutes, if I may. So, first of all, my learned friend has referred to Lord Justice Moses in M. Cashback, quoted at paragraph 5 of Hankinson, which is on page 1297. But it's clear that what Lord Justice Moses was referring to there as restrictions and limitations were in relation to the conditions at section 29, 2, 3, 4, and 5. He was not referring to a narrow or high hurdle to overcome in relation to a discovery. Secondly, my learned friend has also sought to suggest that in order for there to be a discovery at all, someone at HMRC must have come to a prior conclusion that the self-assessment was sufficient in order to then discover it's wrong. But we say that's wrong conceptually because it's perfectly apt to discover by going from a position of no knowledge or belief one way or another, opening up Mr. Tooth's return, seeing what is read on the page, and going straight to the conclusion that what is on the page is that an insufficiency exists. In that circumstance, the revenue is finding out, A, that Mr. Tooth did Romangate, and they didn't know that before they looked at his return, and B, that the consequence of having done the Romangate scheme is that it's had an impact on his self-assessment, and HMRC would not have known that before reading the return necessarily. Now, thirdly, my learned friend's position is contradictory on this point anyway, because he seems to accept that it's conceptually possible for HMRC to make a discovery during the inquiry window anyway. And we say, well, if it's conceptually possible to make a discovery during the inquiry window, surely that presupposes that you've got an officer who's picked up the return for the first time and finds something out when reading it. Fourthly, my learned friend says that if an officer has discovered an insufficiency during the inquiry window, then HMRC can only issue a discovery assessment up until the time that window closes. And we say that plainly can't be right, just as a matter of language, because that would be reading in yet another time limit in relation to those provisions. The relevant bar to assessment is section 29(5), not the word discover. And finally, we also say that discovery shouldn't be interpreted to cure some perceived unfairness with the 20-year time limit, because if that is the target of the perceived unfairness, then that's where the remedy to that has to be found. What I just want to deal very briefly with is this idea, or the suggestion of corporate knowledge, where the staleness isn't itself an issue. So HMRC's position very firmly is that section 29(1) is focused on the assessing officer. It asks, what is the state of his mind? And I think my learned friend even accepted in his submissions that that was a perfectly tenable interpretation of that phrase. What I want to emphasise is that all the jurisprudence on discover, going back to 1913, apart from in the context of staleness, no court or tribunal has ever said that the knowledge of Officer 1 can impose a restriction on the ability of a subsequent officer to reach his own conclusion, i.e. discover for himself. Discover for himself is a perfectly normal and correct usage of the English language. So, for example, I might say that I arrived at the airport only to discover my flight was cancelled. There I am, discovering something for myself. I discovered a great new local restaurant recently. So it is perfectly normal for somebody to be said to discover something by reference only to their own state of knowledge. So we say, and I think my learned friend accepted this morning at around 10:45, that there is nothing in the language that prevents section 29(1) from being interpreted as an officer discovers something by reference to the state of his own knowledge. We say that the different Marie Curie usage would be inapt in this case anyway, because that's actually to say, well, I have made a once and for all discovery by reference to the rest of the world. But that couldn't be right here, literally taking it by reference to the rest of the world, because assume a taxpayer who's made a dishonestly inaccurate return necessarily the taxpayer knows that that return is inaccurate. So what the corporate knowledge test is doing is in fact saying, well, we should interpret the phrase to say, well, discover by reference to the more limited HMRC world. But we would say that's not the most natural usage of the text, of the language. I already gave the example yesterday of if Officer 1 finds out and then leaves HMRC or dies, in that case, no one can assess. So that's an example of why it shouldn't be interpreted like that. And it's critical, as was pointed out in Jerome Anderson, that the discovery assessment regime is practical and workable. And again, because of the sheer volume of self-assessments, HMRC have set themselves up in teams and with systems. And so if a taxpayer such as Mr. Tooth enters the Roman Gate scheme, it's not simply that an individual with no reference to anyone else looks at his return and works it out for himself. The returns are all collated and allocated. And so necessarily a return in Mr. Tooth's case will have passed through a number of different officers' hands. It would be impossible and unworkable if every single officer that ever touched the taxpayer's file had to come to the first tier to give evidence to confirm that they hadn't realised something for themselves when they were looking at the file. So that is why we say that as a matter of text and also principle and practice, it should simply be, has the assessing officer discovered something for himself? And just dealing then with my learned friend's points on the pleadings, I don't want to labour this, but we do say that it is the case that if the test is, had the assessing officer discovered something for himself, and the first tier tribunal made a finding of fact that Mr. Williams had reached that conclusion. This isn't a Burgess case because evidence was put, a case was pleaded, and the first tier reached a conclusion. If you, for your note, it's the Court of Appeals judgment, paragraph 71, little Roman I, PDF 167. There, the Court of Appeal actually says, in October, the discovery assessment was issued. Of course, HMRC had contended from the outset that additional tax was due. This conclusion was not new. And moreover, my learned friend's skeleton argument before the upper tribunal, I think I gave your lordship the page references yesterday. The focus there was purely on staleness, and I would encourage your lordship to look at that. The focus was not on whether or not the quality of Mr. Williams' conclusion was sufficient to amount to a discovery. So he didn't take a Burgess point and he didn't take an Edwards and Bairstow point. My lord, I'm conscious that I am out of time, and your lordship already has all the submissions that we wish to say on staleness, save that in the last 5 minutes of my learned friend's submission, staleness now seems to have shifted to be essentially an evidential point about causation. But we say, well, that proves nothing, because there's no reason why, if the assessing officer gives the relevant evidence, why you should say, well, all of a sudden, the discovery, the conclusion has somehow been denatured over a passage of time. If and only if the Supreme Court does not accept our submissions that discovery should be tested by reference to the state of mind of the assessing officer, then we say, and only then, on any view, the language of section 2.4 CRCA could not be more general. Anything begun by one officer can be carried on by another. So what we would say is Officer 1 discovers, that satisfies the precondition for a discovery to be made, and Officer 2 simply is stepping into the chain at some point and exercising the discretion to assess. My Lord, I think that was a very rushed canter through staleness and discovery.
We have plenty of material from you, both in writing and in your oral submissions, and we'll consider it all very carefully. Well, thank you both. We're grateful to both counsel for their submissions. We'll now take time to consider our decision. Thank you all very much. The court will now adjourn.